It's July 22nd of 2026, and this is the Court Gallery. Today we're covering dockets from across the country. We start in Judge Blanchette's courtroom in Texas, where a defendant tries to school the judge on the law after complaining about jail conditions. Then, we join Judge McNally in Michigan as he delivers a fiery reality check to an 18-year-old with 2 DUIs and a shocking amount of arrogance. And we end the day back in Texas with Judge Stevens, who deals with a defendant that has been dodging probation for over a year and shows up to court having tested positive for drugs. And he didn't come to court realizing Judge Stevens would be doubling his bond to infinity and beyond. All that and more starts right now.
For a long time. I ain't mad at you, dog. That's right, y'all better get me some shit.
Separation 121, please. 121.
Yeah, y'all better come fix this shit, and they gonna come down on y'all. All this whole jailhouse. Better get here and start working.
Step right here. Mr. Judge Blanchette.
How you doing, Judge?
Your name?
Greg Pruitt.
Mr. Pruitt, I'm here, Blanchette, Justice of Peace. I'm
Yes,
here
sir.
today to tell you what you're charged with, read your rights, and see what we can do about getting you out of jail.
Yes, sir.
You are charged of the offense of assault, family violence, a misdemeanor class C. That's
Didn't
a
have-
fine, hang on a second.
Yes, sir.
That's a fine-only offense. You are accused of making an offensive touch to a member of your family, not causing pain, just an offensive touch.
Yeah, I shouldn't be here. I should be here. So go ahead and give me a PR bond or something, Judge, if you don't mind, or something, because I shouldn't have to pay money to get out of jail. And whatever you want to do, you're the boss, but I'm asking for a PR bond. I'm going to court. I'm not taking no charges, no plea deals, no nothing. We're gonna settle this. And this jailhouse, you got jailers letting trustees go out of here with not being searched or nothing. The FBI's gonna be all in on this shit. I've been violated. My rights have been violated all kinds of ways, Judge. They didn't let me poop. They didn't let me sit on the toilet. They ain't gonna let me do nothing. They won't clean these cells. They won't do nothing. Yes, ma'am. Sorry, Judge.
Are you through?
Yes, sir.
Okay, Mr. Pruitt, you have the right to hire an attorney to represent you. You have the right to have the attorney with you while you're being questioned by peace officers or attorneys who represent the state. You have the right to remain silent. You are not required to make a statement, but any statement you make can be used in court against you, and you have the right to stop any interview or questioning at any time. Do you understand those rights?
Yes, sir. I'm not understand, but the thing is, I need to know whose jurisdiction I'm under. Because there has to, in order for me to be a crime, there has to be a victim. There's no victim statement. You can't have a victim statement with a witness statement. A witness statement goes with a victim statement. You can't have a witness statement without a victim statement. That's just against the law. You know that, Judge. That's a deprivation. Okay. Sorry.
You through, Mr. Pruitt?
I'm sorry, Judge. I'm tired. I've obeyed the law, Judge. I'm not a criminal.
Mr. Pruitt, let me explain one thing to you.
Sir.
In an assault family violence charge, the state of Texas has the right to go forward with the prosecution without the witness's permission. That's the only law where that is available. I just want you to know that. Now,
okay.
I'm going to ask you, okay, are you a citizen of the United States?
Yes, sir.
Are you currently on a bond for any other charges anywhere else?
No, sir.
You do not get a court-appointed attorney for a Class C misdemeanor. Like I said, this is a fine-only offense. Do you wish to make a plea before me today? Because it's a Class C misdemeanor, I can take a plea of guilty, not guilty, or no contest.
Not guilty. I will be my own lawyer and I'll show y'all how the cases get beat.
Okay.
I'm good at being a lawyer. I done had 3 cases.
I am going to set you a bond of $500.
Okay, so that means I have to pay $500 to get out?
You can pay $500, or you can hire a bondsman to pay his $500.
So $50. Thank you, Judge.
Now, hang on. Now, do I need to put some type of protective order against you to protect the victim of your crime?
No, my wife knows it ain't no victim. My wife knows that she ain't no victim. She told Lieutenant Hellman told them to stand down and go home. They came back and rearrested me. They can't do that. Lieutenant Hellman told these officers to go home, and he said, if I have to come back out, I'm going to arrest you. And he came back and arrested me. You can't do that. The case is going to be thrown out, so I'm not worried about it. You can't do that. That's a violation of my civil rights. When your lieutenant told me.
I understand. Okay. Your offense occurred in precinct 3, so it's before Judge Elliser.
Yes, sir.
Do you have any other questions?
No, sir. Believe me, I would never hurt a woman in my life. I watched my mom get beat all her life. I would never hurt a woman. This is bull crap. Never.
Okay, post that bond and you can get out.
Yes, sir. God bless you, and I love you, bro.
Thank you.
All right, have a good day.
Are you going to take me to see Mr. Castillo?
Yes, sir. Or I'm not, one of the ladies will.
A lady will, huh?
Yes, sir, one of the ladies here.
I want to get out of here.
I know, we're gonna.
The quicker y'all get me out of here, the quicker I'll show mercy to this guy.
Also. Oh, we gotta take him to medical. We gotta take him to medical.
Because I asked for an aspirin.
Okay. He's in 201. Come with me, come with me. There you go.
Yes, sir.
Mr. Castillo, my name is Harris Blanchette. I'm a justice of the peace here in San Jacinto County.
Yes,
I saw where you had your rights set read in another county and your bond set. And I'm concerned about your mental health. Is it okay?
Yes, sir. I'm more stressed out of cause my wife, she has my 2-year-old, and I've been dealing with this charge, which I already had signed TDC time previous to the charge, which I was expecting to get bench warrant from Harris County when I signed the 2 years to over here to get it out the way, but y'all didn't.
Well, I mean, you do not feel like hurting yourself or someone else, huh?
No, sir.
All right. You have any questions for me at this time?
No, not really. Not really much, sir.
Okay, that's fine, sir. Thank you.
Thank you.
People against Kenneth Mandel McCurdy III, 267843047A.
Ready, Ron? Yeah.
Good morning.
Morning, Judge Attorney John Camilleri, we have Kenneth Randall McCurdy, sir.
Your name, sir? So I want to make sure I got this straight. Defendant on May 24th was arrested for operating while intoxicated. But guilty to operating while impaired on June the 24th. He also had a arrest date in front of Judge Hesselink on April 19 of 26. He was arraigned on that on June 25 of 26. So I just want to make sure I'm understanding this correctly. He goes out, gets one April 19th. I arraign him June 24th. I'm sorry, April 19th, but he goes out, gets another one May 24th. I have the second case.
Correct.
Apparently, the team decided not to accept him in the sobriety court. Judge Hesselink had referred him. And then I heard that yesterday she's gonna continue his bond conditions.
Correct. However, Judge Hesselink adjourned the sentencing that was yesterday until August 12th at 8:45. He had an intake for sobriety court yesterday. They're going to approve him, I suspect, because Judge Hesselink, my client, McCurdy, wants to enter into sobriety court. She believes it's a good thing for him.
Did he pop the bird when he was taking a Silverlink device?
Pardon me?
When he was blowing into his Silverlink, did he pop the bird to somebody? Did you do that? I'll call in the probation officer if I need to. That's what I was told. If she's wrong, I'll apologize. Did you do that?
Yes,
Nice.
We talked about it.
I never talked about it with you.
No,
I was told about it yesterday. I don't get it. Who do you think you are? Popping the bird to the Silverlink people because you went out and picked up 2 drunk drivings at the ripe old age of 18? Who do you think you are? I need to know. I wish I could go through life with that kind of confidence. I really do. I really do. Every time I screw up and I'm called on it, I think they're popping the bird at people. You're 18. If you're running Ford Motor Company, that still doesn't make you able to do that. Do we understand one another?
Yes, Your Honor. Sorry, I do.
It wasn't on my case. But you play games with me like that on this one, you are going to have a big problem. Do we understand one another?
Yes, Your Honor.
What's he thinking? I'm serious. What is he thinking? This is not boys will be boys type thing. He goes out and picks up 2 within 5 weeks, and then he's that arrogant? Tell me you're an All-American in something, and you're going to Harvard to play football or basketball or baseball because you're on an academic scholarship, but you're a great lawyer. I mean, a great student. Tell me that. I want to hear that. I want to know that. I want to know that we're at least not wasting our time with somebody who's going to Harvard or Yale. Jeez. Imagine. If I was 98, I wouldn't think of doing such a thing. You're 18, you're cocky. Who's this? You better make them not so cocky. Cockiness gets us in trouble. Arrogance is our biggest enemy. I don't even know if I should sentence him right now. You know why? Because I don't want to sentence him based upon how I feel right now. Don't say anything. Don't say a word. Do not say a word.
So, Judge, I thought you might adjourn the sentencing.
I'm not gonna be a party to him being in sobriety court. I knew you were gonna answer that. That's why I wanted to bring this up, because he's not gonna act like that. He's not gonna act like that. People that are that arrogant have a 0.0236% chance of succeeding in sobriety. It's my experience. I've been doing it a long time. I have a good mind to send you to jail today. Then we'll see who's popping who the bird.
Well, I suggest that
your client get himself under control before he really agitates judges.
Well, that would be a good thing. I have talked to Mike about with Ken. I think I told him I harp too much. But Judge, here's some of the stuff I write to him. I tell him, look, this is the circle of people who companies want to employ. You got to get yourself in this circle. Now, you're not going to get in this circle unless you have a college education. This is the most likely. Or you get some qualified skill. To get one of these two takes patience, intelligence, and get rid of the ego. You're not going to get in this circle if you have any of that. you know, so.
And he picked up, let's not forget, he picked up 2 drunk drivings before he even graduated. And was not even legally able to consume alcohol. What was the breathalyzer or blood draw on Judge Hesson's case?
0.10.
I cannot believe when he got arrested on the other one, that he went and did the same thing. I just cannot believe that. Go ahead. I'm gonna sentence him today. I'll listen to anything. I'm gonna be fair with him.
Okay.
I mean, I'm gonna still treat him like he should be treated, but he's gonna be on a really short leash with me. Have you had a chance to review the report with him? And are there any material additions, corrections, or deletions? And by the way, he's on a Soberlink right now, right?
Correct.
I ordered that.
Correct.
Go ahead. I'm sorry. Are there
I get it, Your Honor. Judge, we've reviewed the substance abuse screening. It is truthful, as accurate. Judge, there's no doubt, but for me, 34 years of practicing law, I've done a lot of cases. I remember you saying, John, you're here more than any attorney, pre-COVID. So I've never had a case where I've had an 18-year-old or down here close to 18, 2 drunk driving tickets in such a short span. Sure, I've had 30 and 40-year-olds with 2 drunk driving tickets in 6 months. However, so I understand the gravity that's going on here. I know you do. I've talked to my client about it in length. I'm not the kind of guy that shuts his mouth anymore after this many years of practicing law. He passes me on the road just like he passes everybody in this courtroom, and I don't want him to kill any of my loved ones either. So I don't need the money that bad to tell a client what they want to hear. I tell them what I think I should tell them. Your Honor, however, I don't know if Kenny's the kind of guy that is ego, immature, all wrapped in one, and he doesn't drink a fifth a day, or if he's drinking a fifth a day, depending on what type of problem he has with alcohol. You can have a problem with alcohol being immature. You don't have to be, let's say, attached and addicted to it to have an alcohol problem. You could be discounting the risks and not be, let's say, psychologically addicted. You still got an alcohol problem. He's very young. He lost his dad when he was 14. His mom is trying. He works with his mother, and he has been for months. He works Monday through Friday, 8 to 4. He is in an intensive guidance outpatient program at the guidance center. He goes 3 times a week, 4 to 7. He's been on the Soberlink since June 24, all negative. He is going to AA 3 times a week.
Have you seen proof of that today?
Not today.
Show your lawyer your proof you've been going to AA.
He not today. I haven't seen.
I want you to show it to your lawyer right now.
So, and he'll show it to us, Your Honor. So he's doing all the necessary steps to learn about alcohol. However, I agree with you. 2, in a very short period of time, I'm much more of a guy, proof is in the pudding. And when you get 2, that's very concerning. However, he has shown the discipline to abstain from alcohol and take the necessary steps to get cognitively realigned in his head about the risks of alcohol and the abuse and the abuse. At that point, Your Honor, he took a tongue lashing from Judge Hesselink yesterday. We had our
Good.
he had his first sentencing. He adjourned it to the 12th. He will be on sobriety court. From what I can see, well, I asked Judge Hesselink if I could inform you. Is Judge Hesselink inclined to put him on sobriety court? She said yes. Tell Judge McNally, you can state that to Judge McNally. She is inclined to put him on sobriety court. After all, he is going to be doing pretty much the same, if not more, if he wasn't on sobriety court. But Ken, my client,
I thought they were going to put him through another bond phase.
Pardon me, Your Honor?
I thought they were gonna put him through another bond phase for the next 4 weeks. Is that not true?
No, bond phase just until the next sentencing hearing. So we have, 3 or 4 weeks until August 12th. So bond conditions were continued. He has to continue with some sober link. He has to continue going to the guidance center. He has to continue, of course, abstaining from alcohol, et cetera, et cetera.
Go get your AA verification.
Your Honor, continuing, again, yes, he's very mature. The instance you mentioned, I saw in the previous pre-sentence evaluation, if I may approach him.
I don't need you to approach. Has he gone 3 times since I ordered him to back on June 24th? There should be about 12 or 11 of them.
There are 6.6, 6.7.
Okay, I believe you. You don't have to
Yeah.
read them.
He's got them.
Go ahead.
So I brought it up myself. I said, you gave the finger to camera. I've never seen that in 34 years of practicing law. Kenny knew what I told him, complete immaturity, baffling to me that you think that. I don't know what to think about that, actually, Your Honor. Especially in court, I don't think I would tell you what I think about it. So it baffled me. I don't know the psychology behind giving the camera the finger. But it's surely an indication to me that Ken is really immature. And I did tell him,
At a minute.
do that in boot camp. See what happens.
All you gotta do is go out and get one more of these between now and 2100 and you're gonna be a fellow. Do you understand that? You got 75 years. You have to make sure you don't get another one or you're gonna be charged with a felony.
Talked to him about that, Your Honor. I talked to him about the peer pressure. I talked to him about the peer pressure doesn't go away. Even at my age, in my 50s, the peer pressure is there.
Were you in front of somebody when you popped the bird?
What?
Were you in front of somebody when you popped the bird? You just did that for what reason? I want to know. I'm not done talking about that.
When I just woke up.
Just woke up. Oh gosh, I didn't want to keep you up. We didn't want to keep you up. What time was it?
Sure, I forgot what time I do that one.
I went in length with Ken about these cases, Judge. Again, there's a long future for Ken. He's only 18. There are going to be hurdles, and I hope with the realignment and the education that he never forgets this moment and the moment in Judge Hesselink's courtroom. Life is not but a bundle of memories, and memories make a difference. And to me, I'm a big believer in remembering and then taking a left instead of a right when the moments come in life that you have to make good decisions and you remember where you're at today. I'm a big believer in that. And I do have faith in Ken, but it's gonna be a long period. But he's doing everything he's supposed to do. Proof will be in the pudding. I hope the court gives him a chance. Avoid jail. I do believe with the restrictions that he's going to be put on, he's going to be in a form of lockdown. I mean, he has to continue working in the bar. He's been there for months. He's going to have to continue the guidance center 3 to 7, 3 times a week. And he's going to have to continue doing things you're going to require him. Hopefully, corporate program, community service, more education. His life for the next 2 years, he has to surrender to the notion that it's given to something greater than himself, and that's called sobriety and realignment. I mean, his body is not going to want to do all these things, but he's going to have to learn, the mind is going to have to learn that it's for his betterment. So avoid the friends. You're done with that. He's got to surrender.
Remind me, who were you with at the time you picked up this drunk driving?
One of my friends.
They were all 17, 18, and I was wondering what the heck were the parents doing, because the parents were home. And I brought that up with Ken, and I wondered why the police didn't. There was a reason why.
Wait a minute, you guys were drinking at somebody else's house?
That's your
Nice. Well,
So I realized why the parents weren't somehow involved, not his parents, but the parents who were providing,
okay.
and I figured it out.
Somebody was providing you alcohol, an adult?
Yes, Your Honor.
Nice. Really, really good.
I figured out why they were not involved, and somehow with the PD, because Ken was driving.
Really good. I'm just so glad that somebody would think that one through and say, we're going to provide our 17 and 18-year-old kids alcohol and let them go out and drive and just hope they don't kill somebody or themselves.
But that's
Smart. I mean, that's a good gambler.
But that's no
They're
excuse.
betting $100 that, I don't know.
But that's no excuse, Judge. He's an adult.
No, I get it. I'm
I
not
know.
making excuses for them. And I'm not making excuses for him. I just question the intelligence of something. Let's not say intelligence. Let's say common sense of some people. What kind of common sense would cause you to think that that's okay? They're not able to drink. You're giving them alcohol. Somehow they manage to leave driving a car. I'm never amazed. Just not amazed. Go ahead. Anything else anybody wants to say?
I just want to say I'm sorry, Judge. I've stopped hanging around the same friends. I do want to change for the better. I do have a drink.
Turn around and look at your mom. Your mom was looking straight ahead. I watched her. You don't want to disappoint your mother.
I will change for the better.
You do not want to disappoint your mom. You'll regret that. If you don't regret that and you disappoint her, well, then there's something even bigger wrong with you. 2 years probation. You cannot leave, and I'm going to treat this. I'm running a tight line here in this sense. If you get into sobriety court, Judge Hesslink's willing to accept you. I'm going to take into account the fact that this is first in time in terms of sentencing. If she accepts you, you're not probably going to go to jail there, but I will tell you, if you do not comply with my probation here, the probation order that I'm extending it, in which case she's probably not going to accept you anyway. But even if she does accept you, if you don't comply with probation after that, you are on such a thin leash. You have no idea. 2 years probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs and ETGs as follows. Weekly for 4 months. I don't know how you're going to pay for that. I don't want your mom paying for that, but you're going to have to pay for that. Now, if you get into sobriety court, that will run concurrent and the grant will take over. But that's between you and Judge Hess. Weekly for 4 months, and then bi-weekly for 8 months if you're clean, and then monthly. You're to attend AA 3 times a week until you're in an intensive outpatient treatment program with aftercare. I heard what your lawyer said. He told me you're in intensive outpatient at the guidance center, I think you said, right?
Right.
And that's fine if you're already in, and you're in a program that's qualifies as intensive outpatient treatment. You're not going to have to go to AA any longer until and at the end of treatment, in which case it would be considered aftercare. Attend the victim's impact panel. You're to be on a SoberLink device until October the 22 of 26. You're to serve 8 days jail credit, 1 serve 7. I'll let you serve those on the court work program. The court work program, there is a $35 a day charge for that, for a total of $245. You're gonna pay fines $300, cost $250, cost $225, 75 victims' rights fee, $50 justice assessment, $650. Probation fees are $480 for 1,030. Cost of recovery is $150 for 1,180. Screening fee. Did I already count that? Let me double check. 650, 950. 1,030, 1,180. Screening fee is $60 for 1,240 plus your court work program fees. Your total is $1,485. Would you double check that math, Heather? If you violate your
Yeah, I did get something different. I got 1,585. You said cost was 225, correct? And fine.
I think you're right.
300.
I think you're right. 1,585. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. You may be eligible for early discharge in 12 months per statute. You get everything done, you stay out of trouble. In this case, you'd be released. Do we fully understand one another? You got to grow up. That's all I'm going to say about it. And I expect full compliance. If I don't have it, well, it's not going to be pretty for you. Okay. I'm going to let him pay. I understand he's a kid. He doesn't have the money. How are we going to do this? How much can you afford to pay per week or bi-weekly?
Well, he's working, making about 350 to 400. He could pay 150 a month, right?
Yeah.
Okay. If you could.
Yeah, I can do that.
Oh, thank you, Joe.
150 per month beginning August the 8th. How's that? Is that okay? If you don't have the money and you need more time, it's not a problem. Call the court. We'll go on Zoom. I wish you well. I hope you're learning from this. Good luck. Robert Lewis Thornton Jr., 25T6449148, 25W837-260. All right. How you doing, Mr. Thornton? Your name? Tell me what you're going to do here.
He's talking about the probation that found out state and
Hang on a second. Wait a minute. Wait one second. We show cause you for July the 8th.
Yeah, I got an email from my probation officer that you wouldn't be here if it was moved.
Okay. So I have here a case. I don't think he has a show cause in front of me, does he, Heather? His show cause is in front of Judge Hesselink. I don't mind arraigning on that. But I don't think he has one in front of me unless I'm wrong.
Let me take a look here at the case that I'm showing, unless they dismissed it and didn't tell me, but on case ending in 260, I'm showing a show cause along with a prosecutor review.
I see. So it's more of a prosecutorial review. Let me see something here. Who's your probation office?
Miss O'Donnell.
I'm going to ask you to call and let him out get her. Hey, can you come in here on Mr. Thornton, please? Thank you. Thank you. So you have a show cause in front of Judge Hesselink, and you have a review hearing in front of me. And it looks like the charge in front of Judge Hesselink is that you failed to pay your fines and costs ordered, balance owing 270, and you failed to clear all your warrants in the case in front of her by January 31 of 26. So those are the charges in front of her. If you plead guilty, if you're found guilty, It appears as though you have 2 prior technical violations. She could revoke your status and give you 90 days. Do you understand that?
Yes,
Did you sign, read, and understand the advice of rights?
yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes,
You have the right to a lawyer. I'll be happy to provide you with one at public expense. Do you understand that?
yes,
Would you like a lawyer?
yes.
I'm going to enter a not guilty plea for you on her case. I'm going to give you a lawyer. We're going to give you a lawyer on that file. Miss O'Donnell, your name.
That's what I'm.
I'm a little concerned. I'm not sure what I did here. It doesn't look like there were any notes with regard to his review hearing on the resist and obstruct. Has he paid everything on this, Heather? Did you pay on my case?
Yep. On the one ending in 260, he has a balance of 270.
Then you still have a warrant that's still pending as well.
Well, I can't go on this. You got 771.1 status. You blew that. I can't extend it beyond a year. I put you on probation July 23. You didn't comply with probation. I told you a long time ago, son. I said, if you don't have the money, come talk to the court. It really isn't that hard. There's just that amount of time it takes and lesser amount of respect levels. And you don't do that, now you're going to have this conviction on your record.
If I keep in touch with her.
She's not the judge.
And
Don't interrupt. She's not the judge. I'm giving you a lawyer on both of these. I want you to write the notes on the back here. On my case, and then we're going to set you up with a defense lawyer. Who would we set him up with? Who's got a probation today? Is it Mr. Shemke or I don't know?
Well, Crawford's our house counsel and Patillo is overflow.
Okay, I'm going to let you guys figure it out, but I arrange you. I'm entering a not guilty plea. You have to go in front of Judge Hesselink. Your lawyer is going to represent you on both of those. Your lawyer is going to go over this. You should have just come and talked to me. I don't know why you didn't. You know, you got yourself in a real pickle now. I can't extend 771 status past 1 year and we're 360 days. That's the problem. All right, set him up with a lawyer and we'll go from there. Thanks.
Good morning, Judge. Deanna Patillo, P82378 on behalf of Mr. Robert Thornton, station.
I don't know what I can do for him. Here's the problem. I placed him on probation on July 23, 25 under 771.1. I can't go longer than a year. He hasn't paid his fines. Your name again?
That's what I'm.
What else didn't he do?
He didn't clear all of his warrants. He did have quite a few warrants. He didn't clear all of them but one. We're down to one.
I don't know. I gave you a year. You didn't. I told you to get those done by September 15 of 25, not that you'd want to listen.
And then
This is now July the 22nd, right? 22nd? You're late. You got to get us. Go ahead. I don't know what I can do for him. I can't do anything.
Judge, he had a lot of.
I know, but what can I do? It's a year. I mean, I can't go past the year.
He did do the best he could. He got it down to one warrant inside of
Can he pay the 270 now?
He can pay it this week, Judge.
He's gonna have to pay it today because this is the last day prosecutors here, and prosecutor can move to dismiss. But the year expires tomorrow. Go get the money. Can you get the money? You got a credit card or a debit card? I don't know what to tell you. I mean, you don't follow orders.
You can have the 270.
Wait a minute. I can't. The prosecutor's not going to be here. I need a motion from the prosecutor to dismiss this. I don't know what to tell you. You drug your feet the whole time. I told you to come and talk to me if you didn't have the money. Did you do that? No. Because that's too inconvenient. Even though I offered to do it by Zoom, I don't want to argue with you. It's just now you want me to bend over and do something I'm not supposed to do because I have to have a motion from the prosecutor to dismiss your case. I'm willing to overlook the clearing of the warrant if you've only truly got one left And if you can pay the $270 now, I don't have a problem with saying to him, we're okay to dismiss him. But I can't, he's not here tomorrow. They're only in here once a week typically. Some of them are only in here every 2 weeks. What do you want to do? Can you go to somebody and call them and have them pay this?
No, I get my check from work tonight. I was gonna pay it in the morning.
And you can,
Colin, Mr. Urich, I'll tell you what, this now becomes everybody else's problem because you don't listen. But I'm going to go out of my way because if I was as fair as you are right now or have been with us, I'd take your plea, enter the conviction, and resent you.
Judge, if I could, he was always communicating with me about his lack of patience, things like that. But you always ask that they have to talk to you before their due date.
I know.
Always ask that at that point, so I know I'm gonna be worse for to talk.
I know. So then they don't want to do that because that's inconvenience. It's going to take them 10 or 15 minutes to wait only on Zoom. We're going to, Mr. Urich, you got a hold of John?
I got a hold of him coming in.
If he can come in with it in the morning and he's done everything else, you just, Mr. Urich, come on in here. Your name?
The city, wouldn't it?
Defendant here has been dragging his feet and he's still, wait. I'm trying to help you here. What are you talking to your lawyer for?
I asked him.
He can pay it in the morning, right?
Yes.
So would you write up his step? He failed to clear all warrants, but he only has one month. How much does he owe? Does he still owe $270? Is there other fees added in there, Heather?
No, it's still 270, Judge.
You bring in $240 tomorrow. Prosecutor will consider writing up if defendant pays $240 by Thursday, July the 23rd. Prosecutor moves to dismiss and is willing to disregard the fact that he didn't comply with clearing all warrants, something like that. Okay? He only has one left. I'm willing to overlook it. If you don't show up tomorrow, though, there's nothing I can do. All right? You want to come in here at what time?
Probably gonna be off at 6, so can I do 10:30 again?
We'll give you 10:30. We're here to please. We try to help. We're trying to make sure everybody is, the only ones that are inconvenienced is the court. We want to make sure everybody can do these now on golf courses, boats, and their patios, and their summer homes, and you come on in at 10. That's what you want. We'll give you that. And then I'll worry about the rest. We'll write that up, put it in the file. Thank you. Come on in tomorrow. She'll give you a notice. Good luck.
Thank you, Judge.
And then you gotta still set your case with Judge Hesselink though. So Heather, you're gonna have to set his case on a probation violation with Judge Hesselink.
Maybe that's fine. You always look to throw in the.
Or whatever that is.
Oh.
Yeah, this is me
It's
probation.
not a probation, it's a contempt hearing for failure to pay. So you're gonna have to have that hearing set tomorrow too, okay? Or set today. So
Oh.
you'll set that today in front of her, Heather?
Okay. Is he going to go in there today or set it for tomorrow?
No, just give him a date so he can regroup and get his money together, okay?
Okay.
Thank you.
Thank you, Judge.
Cortez Nakari Gordon, 26W843-566A and B and C. Where is Mr. You got him, right, Mr. Slavin? Good morning. Are your appearance?
Good morning to your honor and to your staff. May it please the court, Joseph Slavin, P number 61705 on behalf of Mr. Gordon, who is here with me. Your honor, today's date and time set for an arraignment, and we would like to waive formal reading and stand mute.
Sir, your name, please.
Cortez Gordon.
Okay, so you're standing in for his lawyer of record. It says Thea Barrick, is that right?
That's correct.
And any objection to that, Mr. Gordon?
I'm sorry.
Do you have any objection, Mr. Slavin, standing in for your attorney of record?
No.
Okay, Mr. Slavin, is this a first offense?
Yes, your honor.
He's allegedly got a .127. I'm gonna enter an not guilty plea, indicate he stands mute. I'll give him $1,000 personal bond. Sir, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, marijuana, or illegal controlled substances. Do you understand that, sir?
Your Honor, before he answers that question, Mr. Gordon is a resident of the state of Ohio.
Okay.
He drove up here to be here with me in the office so we could Zoom together and also discuss the case together. With regard to that, he has every intention of being at every
Yeah, I'll
court
be glad to
proceeding.
let him go to the state of Ohio. No problem. I need his new address though, Mr. Slavin.
Mr. Gordon?
23720 Lime City.
Okay, good enough. So we'll give you a court date. I'm entering a not guilty plea on the open intox as well, as I think I indicated, plea of denial on the speeding. And why don't we give them a new court date, Heather?
We can do August 5th at 9:15.
Is that good with you, Mr. Slavin?
Let me check. August 5th, 9:15. Yep, that works for pretrial.
Okay, August 5th at 9:15 will be the court date. Anything else, Mr. Slavin?
No, the only thing, Your Honor, is I guess Mr. Urick made us aware of the new, we're not doing discovery order, we're doing the email to Ms. Parks. With that email and then that coming back, in order for us to see whatever discovery that they're going to have, that might make a little bit of a tight window. Perhaps there might be another date that's at least
I mean,
a
we
week
could, I don't know why
further
he's
up.
saying they're not gonna do discovery orders. I'm gonna sign those.
I mean, all I know is that the new procedure for getting discovery is send the email to iParks.
I don't have any problem with giving you a later date. Let's give them a
Sure.
later date, Heather.
All right, we can do 4 weeks. That's August 19th. We could
At
do 9:15.
August
Okay.
August 19th works well.
All right, that's what we'll do. August 19th at 9:15, okay?
All right. And Your Honor, will that pretrial be by Zoom or will you prefer us in person?
I don't mind you being in by Zoom as long as you're both in the same place. I'd really prefer that. So you
Sure.
can either both be here or both be in your office or.
Very good.
Okay,
Thank you, Your Honor. Yep.
have a good day. Thanks.
You do the same. Thank you.
My name's Kish, Eric Stefan Kish, 25F244490. Did we set you up with a lawyer yet?
Yes, I already spoke with Mr. Crawford.
All right. I'm gonna need,
Morning, Your Honor.
Beth in here. John Beth.
Kish, you stands to my right.
All right, Mr. Kish, your name?
Eric Kish.
The charge is failure to refrain from consuming alcohol, testing positive for alcohol on a chemical test from DNA on July 13 and 26. How's he going to proceed?
Your Honor, my client and you to take responsibility. That's all information you'd like to share.
Plead guilty here, you could get 10 days. This would be a second violation. No, actually, you've had 3 priors. You could get have your probation revoked and you could be incarcerated for the maximum, which on this would be 93 days. Do you understand that?
Yes, Your Honor.
You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena power of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, any questions before we go on to that charge? Failure to refrain from consuming alcohol, testing positive through DNA on July 13 and 26. How do you plead with that?
Guilty.
Did you test positive at DNA on July 13 and 26?
Yes.
Did you consume alcohol, say within the 3 days preceding that?
Yeah.
Anybody force you to plead guilty?
No.
I'll accept that plea. I find it to be an accurate plea made voluntarily and understandingly. So that this is the summons via probation violation of July the 20th. I'm accepting your plea here today to fair to refrain from consuming alcohol. Your name is Wells.
Elizabeth West Probation.
All right, so what do you have to say here, counsel?
Well, Your Honor, as I understand, this is really an accident. He went out for a golf trip on the weekend. He went out there with all intents and prepared to act responsibly. He brought several non-alcoholic beers with him so he could stay distinct from his buddies. And the only way he can explain his possible exposure that he grabbed one of the wrong beers, so they owned one of the wrong beers.
Oh my gosh.
What happened?
You guys, they're not even getting, how do I say, unique any. Look me in the eye.
Yeah, can I say something?
No. Did you intentionally consume alcohol on that day?
Not intentionally. I did.
Then let's have
I did have a beer.
Yep.
I had 3 non-alcoholic beers in day.
Slow down. I'm not taking your plea. You didn't intentionally consume alcohol. If you didn't intentionally consume alcohol, I'm going to swear her to an oath. I'm going to swear you under oath if you choose to testify. And we will go from there. You want to confer with your lawyer before you answer that question?
Yeah.
Go ahead, talk to him.
My client would like to maintain his guilty pleas. Disgusting.
Did you intentionally consume alcohol?
Yes.
Why did you just tell me you didn't intentionally consume alcohol? Wait a minute. Before you answer that question, you have not learned the single most important principle of a sobriety. And that's honesty. I don't want people in the sobriety court that aren't honest. I get the fact they're going to relapse, but I don't want them in here if they're going to look me in the eye and tell me something that isn't true. And I know not to be true. I mean, this is not, I don't understand how it is that anybody who comes in here and is concocting stories would think they're going to get one over on me. I don't take it personally that they think they are. How old are you again?
34.
All right. Well, I've been doing my profession for 43 years and a judge until the time you were about 2. So, and I'm talking about being a judge. So that means I've heard every story from A to Z. Every story, every lie that there is to hear. I don't want you in sobriety court if you're not going to be honest with me. I never liked you working at this bar to begin with. You got no business putting yourself in a position where you're going out on golf outings. I know what happens on golf outings. And now you come in here and you lie to me. No, wait a second. Why you stop?
Well, Your Honor,
He said he intentionally consumed alcohol. If he didn't intentionally consume alcohol, we're having a hearing right now, and I'm going to determine whether or not he intentionally consumed alcohol.
Your Honor, I think it's true. I think my client admitted that it's true that he knowingly took alcohol. But in terms of the use of the word intentional, I think upon reflection, what he was trying to communicate to the court, that when he came to this golf outing, he didn't come with the intent of hanging out, having drinks with his boys.
But he did anyway.
But he came with the intention. That's why he brought the non-alcoholic. He was thinking he could toe the line. And this was one of those times when he failed. He relapsed. When he put himself in a bad situation.
So what I would have expected is that he come in here and tell me that. Anybody force you to plead guilty here?
No.
Please accept it. But I don't know what to do with it. You tell me what I should do with it.
I honestly, Judge, I don't know. I mean, we just went through this a very few short months ago in regards to, of course, his prior violations, him claiming the non-alcoholic beverage, finally kind of came to truth. I was hoping he learned his lesson about being truthful at that point, especially since he served a little bit of jail time. But we're in a position now where we're kind of far enough in the program that it has to be considered if he is appropriate to continue. I think Mr. Kish, as I think I've said before, it does have a serious problem with alcohol. environment he's in, like you mentioned, is just not a good environment. To put himself in the predicament of the tournament. He knows he can't possess frequent, and that's exactly what you're doing when you get on a golf cart or you go to a golf tournament and there's beer in the basket. You know, maybe he should have left. That would have been the better choice. So I'll leave it up to the discretion of the
What
court.
about the restricted license? Where are we with that?
We took that away from
Right.
him
Right,
because he attempted to drive with.
right. And they go,
Well, Your Honor, but I understand that it appears to me that the actual prior violations was for him failing to provide a sample. In other words, shy bladder syndrome, and I believe he supplied some type of documentation to the court, if not, he can. And that's why he was really violated. I can't speak to some of the other comments here. Pardon me. So I would just hope the court can kind of emphasize on exactly what it has been found guilty of. It's failure to test after attempting to several times. It's clearly documented. He attempted 3 times.
I think I dismissed
Mr.
those.
Crawford's looking at a very previous violation.
I think I dismissed that.
Yeah, he's violated for consuming alcohol, attempting blowing.
I did take a plea on one for failure to submit. I took a plea on one for failure to pay fines and costs. And I took a plea on the last one for testing positive, at least on the interlock. So I'll grant you this. He's really had 2 violations for drinking. And he had the one for failure to pay, which I'm not as concerned about, to be honest with you. And then the other one for failure to submit. But I remember we went through that shy bladder issue.
Thank you, Your Honor. Bottom line is my client is asking the court give him this one final chance. He believes his final court is good for him, wants to continue on. I find it difficult how the court might resolve or ask my client to resolve the issue about his employment. It's my understanding is that he owns the facility. So
I get it.
I mean, he has to somehow interact there to properly exercise his ownership.
Where is he phase-wise?
Your Honor, I didn't bring my face sheet in. Eric might have a better answer for that. I know we had
Tell us where
extended
you
up,
are.
but I believe we put him.
I know, but how far through 2?
It was about a month ago,
Yeah.
and it got really tornado siren.
Yeah.
And then it closed down. That was when I was supposed to phase up, and then actually she gave me the paperwork last attribute. So
Here's what I'm doing. What do we have him now? Testing twice weekly?
Yeah, he is in the full benefits of phase 2.
We don't have him a sober link, right? Or do
Not anymore.
I'm going back on the sober link. You're going back on the sober link at your expense. And you're to pay for your own testing until September the 20th. So I want him back on a sober link by the end of the day. I want him paying for his own testing. I want him paying for his own sober link until September 20, and you're to serve 3 days jail. So you're to report to jail. I don't know how we can work that out because we're going to be closed probably when I want him back on a sober link. And I don't want to make a condition on him getting the sober link because they might not get him out if they send him to Detroit. So
Then on release on, assuming he goes into custody now, if he's released late Friday or early Saturday, as far as Wednesday, Thursday, Friday, he can go directly to house arrest
you're to
services.
obtain a sober link within 12 hours of the time of your release. Do you understand that?
Yeah.
It should have been a lot worse. I'm going to give you a last chance. You got to take this more seriously and you got to be more honest with me.
yes, sir.
I wish you well. Good luck.
This is the State of Michigan versus Tracy Bunker. There are 2 files. The first is 26-44708-FY-3 set for a hearing. And then we also have 26-44737-FY set for an arraignment. Mr. Bunker, I'm going to arraign you. That is, I'm going to tell you what you're charged with, tell you what your rights are, and then set bond. That is in the new file. And then we have a past file, which is still pending, where there is a motion regarding a bond violation, and we'll get to that as soon as we're done with the new arraignment. In the new file, Let me read the charge to you. Complaint says that on or about July 21st of 2026 in the city of Gaylord in Otsego County, that you did commit the following 2 offenses. Count 1, the name of it is police officer assaulting, resisting, and obstructing. And it says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Greg Cates, a sheriff or deputy sheriff of the county of Otsego, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is a felony offense and has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the name of count 1?
Yes.
You understand the maximum penalty for count 1?
Yes.
Count 2 says that on that same date, time, and place that you did commit the offense called domestic violence. And it says that you did assault or assault and batter Samantha Jo Gibson, an individual with whom you had a dating relationship contrary to the Michigan compiled laws. That is a misdemeanor offense, has a maximum penalty of 93 days and or a $500 fine. Do you understand the name of count 2?
Yes.
Do you understand the maximum penalty for count 2?
Yes.
As to each of those charges, you have the right to have a trial by a judge or by a jury. You have the right to be represented by an attorney. And if you cannot afford an attorney will be appointed for you. And you have the right to plead guilty, not guilty, or to stand mute. Let me explain the trial rights to you first, and then we'll talk about your right to an attorney. At trial, you could be represented by your attorney. As I indicated, you would be able to see, hear, and question all the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. At trial, you could testify, or you could choose to remain silent, and that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've given you?
Yes.
Do you have any questions about any of those rights?
No.
All right. I have 2 attorneys with us. Mr. Dick is here on the older file. Mr. Truce is here on the newer file. Mr. Truce, if you had a chance to speak to Mr. Bunker about his right to an attorney.
I have, Your Honor.
Does he qualify for court-appointed counsel?
He does.
All right. Likely it will be Mr. Dick because he's on the previous file that you have, but until that appointment is made, I have to assume that somebody else may be involved, so I don't know that yet. So what I'm going to do, Mr. Bunker, is I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your attorney about how you want to proceed in these matters, so that will protect your rights. Because you're charged with a felony offense, I'm also going to set a couple of quick court dates also to protect your rights. The first is called a probable cause conference. That'll happen within the next 7 days. That's a chance for your lawyer to speak with the prosecutor and see if they can resolve the case quickly. Within the next 21 days, you'll have the opportunity to have a preliminary examination, and that's a hearing in front of me in district court, and where I will be the judge, and the prosecutor will be required to bring in a small amount of evidence called probable cause that you've committed the crime that you've been charged with. It is not a determination of guilt or innocence, but simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions as to those two hearings?
No.
All right. We're then going to turn to the matter of bond in this case. I'm going to hear from both of the lawyers, and then I'll give you an opportunity to say anything else that you want me to hear before I decide what to do. Mr. Fortier, as to bond in this matter, what are your thoughts?
Judge, I think a 5,000, 10% would be appropriate. Mainly just because of the severity of what he's doing. I mean, here you have a second alleged domestic violence to have taken place, and then couple that in with now resisting police officers. He already has that open file. I'm sure that we're about to address that here in a moment, but that would be my request as far as the monetary amount goes. I think that the same bond conditions should be in place, that he shouldn't have contact with the victim, no drugs, no alcohol, no bars, random testing, report via community corrections. And I did receive an email from Mr. Trush shortly before the arraignment started that he had contacted Jessica Van Wolfen with Community Corrections, and she had indicated that there was a GPS tether available. So I would ask that the court consider, as part of not only this case, but also the bond violation that it's about to bring up, that it consider that jointly, but to put a tether in place, because that has adequate safeguards that Ms. Van Wolfen can essentially put the victim's residence as an out of bounds zone. So it would send an alert if he's in that area again.
All right. Thank you, Mr. Fortier. Mr. Trush, your thoughts on bond?
Thank you, Your Honor. In terms of the proposed bond from the prosecutor's office, I think that's a reasonable bond given the circumstances. I did attempt to send the same information over to the court, but I got an email back that I think Mr. Horrigan might be gone for the week. But ultimately, Mr. Fortier identified Mr. Bunker actually was the one who suggested to me that a GPS tether might be helpful as we were talking about the alleged bond violation. I think it's a good idea. It would give an added layer of protection of knowing that if he was in that area, law enforcement would essentially be immediately notified. And the tether can be set up in a variety of different ways, as the court's probably aware. It can have exclusionary zones, which is areas that he's not permitted to be. It could also be set up really to just have areas he is permitted to be. So effectively like a house arrest type situation. He reports to me that at present he is homeless, but he is optimistic that he may have that sorted out here shortly. Thank you.
All right, I have a question for both of the attorneys before I speak to Mr. Bunker. MCR 6.106, the court rule on pretrial release, subsection 1A, subparagraph 2 says that I may deny pretrial release if there's a violent felony and there's at the time of the commission of the violent felony, he was on probation, parole, or release pending trial for another violent felony. Isn't that this situation where he's on bond for assault with intent to do great bodily harm and he commits resisting and obstructing another felony while he's on bond for the previous violent felony?
I don't know if resisting and obstructing is classified as a quote unquote violent felony.
Violent felony under subparagraph 2 in that same court rule says a felony, an element of which involves a violent act or a threat of a violent act. Resisting, obstructing talks about assault, batter, wound, resist, oppose, or endanger. That sounds like a violent act to me.
I guess at this point I would leave it up to the court. I did not consider that when making my initial bond recommendation. So,
Mr. Trush?
So, Your Honor, I think to the extent that the court was inclined to do that, I think the court has the authority under that court rule to do it. I don't read that, and I don't think it requires the court to take that action. I'm not convinced that these are the circumstances that require it. I think that, again, crafting conditions and putting that GPS tether in place would provide adequate safeguards short of taking the extreme step of holding him without bail. But again, I ultimately would concede to the court. I think that court rule does ultimately vest the court with the authority to do that should they choose to.
May I say something? Yes, I'm going to let you have that opportunity in a minute. I just wanted to address that legal issue with the two lawyers first, so that I had that square in my mind when I was listening to you. So you now have the opportunity, Mr. Bunker, to address me. Let me just caution you with one thing. We are recording this, so I don't want you to say anything that could be used against you later as to the facts of what happened. But I would certainly be willing to listen to whatever issues that you want to bring up as to bond. So this is your opportunity to do that, sir.
All right. When I was arrested last night, I was terrified to be tackled because I have fractured ribs, and I was begging him for not to squash me because my ribs were hurting really bad. I did request a hospital visit, So I wasn't exactly resisting. I just didn't want to be tackled.
Anything else that you want me to know, sir?
I would like you to know that I want to get it to, what's the name? Just there's a medical help group. I forget the name of it, but TJ Johnson gave me the phone number for it. And I'm also trying to get a hold of Pastor Jeff as for looking for housing. I did also have an interview for a job tomorrow that I'm greatly positive that I'm going to get the job. I just need to be there. That's all I got.
All right, thank you, sir. The issue on bond for the court is twofold: whether or not the defendant will appear as required for any court date set by the court, and then it is also protection of the community. Mr. Bunker is currently on bond to the court on a very serious charge of assault with intent to do great bodily harm. This new charge of assault, resisting, obstructing police officers and domestic violence involves the same victim as the previous file. And then it also involves the new allegation that he fought with the police or was resisting the police at least that's the charge made against him while he was on bond. That the previous file was, bond was set, I believe, on July the 10th. So here we are less than 2 weeks later, and he has caught another felony offense. I understand Mr. Trush's argument that this is not a overly serious felony matter in the grand scheme of things. It's not another assault with intent to do great bodily harm, but it is, in my mind, scary because he's alleged to be at the same address as the victim in the previous case. She has to call the police are called, and then he fights with the police while he's on bond for assault with intent to do great bodily harm charge. At the very least, he needs to sit in jail until he figures out that he can't do those kinds of things. So I am exercising my discretion under MCR 6.106 B sub 1 subpart A2, where he has committed a violent felony, that is resisting and obstructing police, and is on probation, parole, or on release pending trial for another violent felony, that is assault with intent to do great bodily harm. I understand that there's a ticking clock on that. Up to 90 days, we would have to have a trial. That probably is not going to occur, but that will then allow a review of bond at that time. And his counsel, whoever that may be, may bring another motion regarding bond in the future. But I think it's necessary at this point for the protection of the victim to set Mr. Bunker in jail. So I am denying bond on this matter. And I will review it again in the future once that a motion is brought in front of me. All right, now I'm going to turn to the other matter, which is 26-44708-FY, which is the assault with intent to do great bodily harm file. He's also charged, that's count 1. He's also charged in count 2 with domestic violence on Samantha Gibson, the same victim as the case we just got done doing, and there is a complaint for a violation of bond filed by the city police department. Mr. Bunker, please listen carefully. The allegation is that there was a bond release for you, which said that you were not have direct or indirect contact with Samantha Gibson, and the allegation is that the officer has reasonable cause to believe that on July 21st, at approximately 13:55 or 1:55 in the afternoon, you violated those conditions and had direct contact with Samantha Gibson. As to that allegation, you have the right to have a contested hearing in front of me as the judge. At that hearing, you could be represented by an attorney. You'd have the right to see, hear, and question the witnesses. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. At that hearing, you could testify or you could choose to remain silent, and that silence cannot be used against you. At the hearing, you'd be presumed innocent until proven guilty by a preponderance of the evidence, and that burden of proof would remain with the prosecutor's office, and you'd also have the right to appeal. Do you understand the rights that you have as to that hearing?
Yes.
The violation of that, if you were found to be in violation, would be a contempt of court charge, and you could be jailed for up to 93 days and or fined up to $500. Do you understand all of that?
Yes. So how long is my sentence right now?
You don't have a sentence right now. I'm going to ask your attorney in just a minute how he wants to proceed with this bond violation. You're still on bond in both of these cases. The allegation is that you violated your bond, and you could be sentenced on the bond violation alone, not the criminal case, but on the bond violation. You could be sentenced up to 93 days and or a $500 fine. Mr. Dick, how would you like to proceed on this bond issue?
Your Honor, if you would be willing at the present moment, just have this adjourned to the next hearing date. I was intending to go and speak with Mr. Bunker at the jail after I got off the phone with Mr. Fortier, since I was informed about this violation hearing earlier. However, I had a couple things come up and I didn't make it before this hearing. I did not have an opportunity to speak with Mr. Bunker previously, as I did not have a good contact number or email for him. The letter was sent out, but I now have his phone number and his address, and I can go visit him rather promptly.
All right.
I no longer have a phone.
That was just a little bit of me making a joke. I apologize. I know
he knows where you're going to be for the foreseeable future, so he'll come see you at the jail.
Okay.
Attorneys sometimes talking the long way around, so I apologize for not making it clear to you.
Okay.
So I will grant your request, Mr. Dick. We will set both of these matters as quickly as we can. Prelim will be set in the other matter. We'll schedule this hearing for that same. Well, let me see what we've got. We've got a. See what the next date is in this matter.
30th, Your Honor.
Yeah, the 30th, I believe. Let's find it. Yep, July 30th at 1:30. So we've got about a week. Today's the 22nd, so a little over a week from today, we'd be back in court anyway. And if there's something new that you want to do faster than that, we can certainly try to fit it in. But that probably is going to be the easiest place to do it at. So we have a status conference on the 30th. We have a preliminary examination set for August 6th. As of right now, I'm just going to leave all those things on, and we'll take up the matter of the bond violation at that status review on July 30th. Any other thoughts that you have on the matter, Mr. Dick?
No, Your Honor, not presently. Thank you very much.
All right. Mr. Fortier, anything else today?
No, Your Honor.
All right. That's what the court will do. That will be in recess then. Thank you very much.
This is file number 251295 FH, People of the State of Michigan versus Craig Klein. Mr. Klein is present. Please have a seat. He's here along with his attorney, Ms. Amy Lou Houston. Mr. Kerner here. He's our elected prosecutor. Agent Hobson from Michigan Department of Corrections is present too. I'm aware that Mr. Klein was sentenced by this court back on March 27th of the year 2026. One of his orders of probation is that he's not to have any contact with Kimberly Page. I did say that at some point down the road, I would consider amending that provision to allow contact. Ms. Houston is now asking the court to make that official. Ms. Houston?
Thank you, Your Honor. Your Honor, I get up to the podium. Mr. Klein has been residing on Bennington Road in Langsburg, Michigan. He has been attending therapy at Catholic Charities. He has also been having some medical issues and has to have surgery on his stomach. We were hoping that perhaps this, the no contact between him and Ms. Page could be lifted so that she would be able to assist caring for him after the stomach surgery, if that is at all possible.
Thank you, Ms. Houston. Mr. Kerner?
We'd leave it to the court's discretion. It was my understanding there was going to be a safety plan. If that's acceptable to the court, then acceptable.
How many times did you estimate those two were in district court involving a domestic that either ended up in adjudication or dismissal over the years, Mr. Kerner?
Over 15.
Over 15?
Not adjudications, but.
Or I said adjudications or dismissals.
Or calls or, yes, disturbances.
Yeah, I'm true to my word. I said that if I were to see some progress with Mr. Craig, I would consider lifting the no contact order. I believe that I heard from Miss Page from her side of things, and I got her counseling records, and I think she was good to go. But this is what I got from Mr. Craig. Per the client's request, I am writing to verify that he is currently enrolled in treatment. That's great. But then it goes on to say, at this time, the client has authorized me only to confirm his enrollment. He has not provided consent for me to disclose any additional information, including his attendance, participation, progress, or any other treatment-related details. What is this? Why would I get just, he's here, don't ask me anything else because I'm not telling? What is that, Ms. Houston?
So, Your Honor, Mr. Klein, in order for the therapy to work, has to be very open and honest, and he is concerned that if he does that, they would report directly to the court if he signed a carte blanche release of information, and that it may negatively impact him. That's not all that unusual. Back when I used to practice abuse and neglect cases, we often had parents who would release for attendance only as well.
Okay, but this is circuit court. This is domestic violence related, and just verifying he's in treatment does nothing. He could have never went. He could be the worst patient ever, and I wouldn't know that. You're wasting my time by just letting me know you're in counseling without giving me the substance for it. So your motion is denied. Don't waste my time again. I'm insulted that you would just say I'm not. Why are you talking while I'm talking? Why would you just let me know that you're in counseling and then make it a point to say that I don't get to know if you even go to counseling? Motion is denied.
Thank you.
No, you don't get to give me just what you want and not give me the whole picture. It's not fair.
It was all signed right. I didn't know nothing about this.
It's not fair.
All right. Next one we have is State of Florida versus Joseph Elrod, excuse me, Mr. Jones. If you'll come down and have a seat where Mr. Killian's at. Mr. Jones, you're before the court today for your evidentiary hearing based on the affidavit of violation of probation. I've found that you're competent to represent yourself. However, at any point in time, you can ask that an attorney be appointed to represent you. Do you wish to have an attorney appointed to represent you at this time? Okay, Mr. Sullivan, you prepared to go forward?
Yes, Your Honor.
You may call your first witness.
Your Honor, State Court Officer Cosby.
Yeah, if you don't mind, because he could still ask for an attorney, and I'd appreciate it. All right, sir, if you'll raise your right hand, please.
Comments for the testimony you're about to hear.
I do. Matthew Cosme,
Officer Cosby, where are you?
the Panama City Police Department.
And what do you generally do for Panama City?
I'm on the Special Operations Unit with the K-9 unit.
I want to take you to, first let me ask, are you familiar with the defendant, Joseph Jones?
I am.
How are you familiar with this?
He was a person on a traffic stop.
Were you working on April 20th of 2026?
I was.
Yeah. Were you the officer that conducted the initial traffic stop in this particular case?
I was not.
Who was?
Officer Chawan Boros.
And how did you get involved?
He requested me over the radio for a K-9 deployment.
You showed up to the scene of the traffic stop?
I did.
Were there multiple individuals in the vehicle that had been stopped, or who was there?
When I arrived, there was only the driver on scene, which was the defendant.
Okay. Mr. Jones was the driver?
Correct.
And did you attempt to perform your K-9 step? Beginning to begin that process?
Do is I go up there, I explain who I am and what it is that I do in my position. Then ask them to step out of the vehicle
And why do you ask the defendant to step out of the vehicle?
for officer safety issues.
Did Mr. Jones comply with that request?
He did not.
What did you do?
I gave him numerous warnings to exit the vehicle or that he would be placed under arrest. He continued to say that we needed a search warrant and continued to be argumentative. At which point, I opened the door from the outside and he tried to snatch it back and shut it.
Were you eventually able to get Mr. Jones out of the vehicle?
Correct.
How did that process play out?
So I opened the door. He began pulling away from me. I grabbed his wrist. He then grabbed my wrist, tried to pull me towards the vehicle. I was able to free my wrist. And then Boros had seen that we were at this point being physical. So he came out of his patrol vehicle, ran over to me, and we were able to extract him with some stuff that we were taught.
When all of this began, was Officer Boros continuing to affect the traffic stop paperwork?
Correct. He continued to work on his citation or whatever paperwork it is that he needed to do.
And were you ultimately able to place Mr. Jones under arrest?
Yes.
For what?
Resisting without violence.
At that point, were you able to conduct the canine sniff?
After he was placed in the back of a patrol car, yes.
And what was the result of that?
My canine alerted to the presence of the odor of narcotics from the vehicle.
I'm sorry, I didn't understand that.
My canine alerted to the presence of the odor of narcotics emitting from the vehicle.
Based off of the canine alert, what did you do?
We then conducted a probable cause search of the vehicle.
And did you find anything?
We did. We found, I believe it was two glass pipes that were used, that are commonly used in just crack cocaine, and they were underneath the driver's seat.
Were those two glass pipes field tested?
Yes.
Did you field test them?
I did.
And what was the result of that?
So the white, they turn blue when you field test cocaine or crack cocaine, and that's what they turned at the station.
So both of those pipes field tested positive for cocaine?
Yes.
I've got no further question, Your Honor.
All right, Mr. Jones, you're a witness. You're a witness. You can ask questions.
Oh, I'm sorry, yeah. But, okay, I'm not real good at it. But now, he said that, they pulled me for a traffic stop. But I wasn't, but I got pulled for a traffic stop, but I had no reason when the officer asked me to get out of my car, I told him, I asked him for you.
Hold on. I'll allow you to testify, but if you want to ask this,
I don't, but see, I don't remember him. I remember the one that arrested, the one that pulled me. The one I remember talking to until they snatched me out of my car, and then but see, that's the one I remember. It wasn't him, and the dog did not, and I know for a fact that the dog did not alert.
hold on, Mr. Jones.
Oh, okay, I'm sorry.
I want to question the witness. This is your time to question. If not, I mean, you don't have to. It's up to you.
No, I like to question the one that actually pulled me over. That's the one
He's not here.
But see, because that's the only one that I actually talked to. And see, like I said, I don't remember him.
Okay.
Asking me no question.
If you don't have any questions for him, that's
No, I don't have no question for him.
Okay. Can the witness be excused?
Yes, Your Honor.
Sir, you may go back to your day.
Thank you.
All right, Mr. Sullivan, you can call your next witness.
No further witnesses, Your Honor.
Mr. Jones, you can call your first witness.
Well, I said, I don't have no witnesses except for that one that pulled me over. That's the only officer that I seen that I could ask questions because that was the one that I was involved with.
Okay, well, he's not here. If you don't have him subpoenaed, he won't be here.
Well, I haven't had time to do nothing, get no subpoenas or get no paperwork on that. Because I don't, what all.
Mr. Jones, I indicated that we were going to an evidentiary hearing this morning. I gave you an opportunity to have an attorney appointed to represent you, and you declined that.
Yes, but I've been here all day. So.
I understand that, but you still have to, it's up to you to have all that stuff done. Since you represent yourself.
I understand that too, but I didn't have the material to do it because
you didn't
forms that I was trying to get.
You didn't ask for a continuance. You didn't indicate that you weren't ready to go. It was set at least a month ago with the evidentiary hearing. So you can testify yourself, or you can, whatever you'd like to do.
Yes, I understand it too, but I was going to go to a law library, but they didn't have what I needed in there.
I understand that, but I can't do anything about that. But are you prepared do you want to give any testimony? If you don't, you can rest and we'll go forward from there.
All right, so I'll testify on my own case?
You may, but you have a right to remain silent. That's up to you.
Okay, I'll remain silent at the moment.
Okay, all right. Mr. Sullivan, argument?
Your Honor, you heard the testimony of Officer Cosme. It's a violation of his supervision. He was on probation. He committed 3 new offenses: battery on a law enforcement officer, resisting without violence, and possession of paraphernalia.
All right. Mr. Jones, any argument?
Yes, I did not, I feel like I didn't violate my probation because I did nothing wrong. I was just pulled for a traffic violation, which I was pulled for a certain thing in which once the officer ran my license, he said, I guess for my prior history, because he said I had history with the police department in there, I was mad, I wanted to search my car, which they had no cause to search my car. Because I actually did nothing wrong.
Okay. All right. Is that it?
And then from there, escalated into they tell me got a car, and I told them no, either a search warrant, and then just word between the officer and me, which was not, and then went out, they would pull my door open and snatch me out. I did not grab nobody arm. I was in my car, inside my seat. In the seat belt, I had no way of reaching, grabbing no one to pull them. So I don't know why he would say that I pulled him when I didn't. He had my left arm pulled back towards the back of my vehicle. And I was in the right into my driver's seat, my right hand on the steering wheel, inside the seat belt. So there was no way I could have did what he said I did. As far as, on my paperwork, it said I touched him against his will, but I couldn't touch him because he grabbed me.
All right, anything else?
That's it.
I'm gonna find that Mr. Jones willfully violated the terms and conditions of his probation by committing the new acts of resisting without violence, battery on a law enforcement officer, and possession of paraphernalia. I'm prepared to go forward with sentencing. Mr. Jones, do you still wish to represent yourself at this stage in the proceedings?
Yes, sir.
Okay, and have you sent a copy of the score sheet?
No, sir, I haven't seen nothing.
All right, let's show Mr. Jones that score sheet.
$40.4.
All right. State wish to be heard on sentencing?
And it has multiple felony convictions. He's got 5 priors in addition to the 2 that he's on probation for. I'm asking, the defendant doesn't have an lowest permissible sentences. I believe with this violation only, his total sentence points are 40.4. I'm asking for a sentence of 2 years in prison, Your Honor.
Mr. Jones, you wish to be heard on sentencing? And I've already asked that you would like to have an attorney. I think you're still want to represent yourself. Is that correct? Okay. You want to be heard on sentencing?
Yes, I represent myself.
Okay, go ahead. Tell me if you want to say something prior to sentencing.
I'm saying I don't know. He said prior charge. On the prior charge I had, I served my time for my prior service. Offense he had, and I was on probation for that one. And that's why I don't see, and then this come up, but I know I didn't commit no crime. And like I said, and they said found paraphernalia in my car, which they did not find in my car.
How much credit? I'm sorry, go ahead.
Yeah, so a lot of stuff they saying, like I said, on the paraphernalia, they didn't find it in my car. I had no drugs, no paraphernalia in my car. And I did not violate no law to be stopped. That's why then they stopped. Then they said I was stopped for a certain reason. But that officer that was there, see, like I said, I didn't know I had the subpoena and all this, so I just had to go with, I guess, with what I would come up with, and then I just do an appeal or whatever I need to do.
Okay.
Bring it back.
All right. How much credit does Mr. Jones have?
164 days on the VOP, Your Honor.
You agree with that, Mr. Jones?
Yes.
Okay. All right. Well, I'm going to find that I've already found he willfully violated the terms and conditions of his probation. His probation was revoked. He's adjudicated guilty of possession of cocaine, possession of a controlled substance, He is sentenced to 24 months to Florida Department of Correction on each one, to run concurrent with each other. He's given credit for, how much is that, 64 days on each count. All fines and costs previously imposed are reduced to a civil judgment. There's an additional $100 imposed. That cost you, please. Cost sheet on the BOP, $100. That's also reduced to a civil judgment. Mr. Jones, you have 30 days to file a notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, and you can't afford one, one may be appointed to represent you at no charge. Good luck to you, sir. You need to step over and be fingerprinted. And on the new charges, we want to set in for maybe the 20th.
I'll take care of it, Your Honor.
Okay.
He can be transported to DOC.
All right, he'll go ahead and be transported to DOC. We'll go ahead and set just a tracking date for August 20th.
Thank you, Your Honor.
Yes, sir. Thank you. Hold on just a second. Let me talk to y'all just for a second.
Renier. I have Brenya Boudreaux. It's, let's see, Brenya. It's what? Brenia. Okay, so it's 3 syllables in it. Wow. And Mr. Turk is here. You've got the state jail felony of credit or debit card abuse. And what are we going to do? It's $47.65, huh?
Yesterday, I filed a motion to increase her bail based on the fact that there's been another accusation of a theft from June 27th. And that came up the last time she was here, and we reset it here. It's still in the process of it being filed. I've talked to our intake, and I don't understand why they haven't actually processed it formally, but it's in our office. I know the charges have been accepted. It's just not gotten to the stage.
Details about it.
This is the probable cause, which has been provided to the defense. But
is this a copy for me?
Yes, sir.
And the file?
You can have that.
Thank you, because I'm going to highlight.
You said you filed that motion yesterday, didn't you?
I did. I showed that it was accepted.
Okay.
But
I just didn't know
Yes, ma'am.
this morning.
Yes, ma'am.
So
Let me print that
in
out.
case
I have the motion for you, Joseph.
I haven't.
I do know we're going to prosecute that matter. We're going to do that as an organized retail theft. It's the PC is as engaging, but there's a separate portion of the theft statute that we're going to process on organized retail theft.
What is that?
Same, it's still the same level of offense. Yes.
I'm older. That's still 3 people to get that. It's within 2 months. I have to look. I was looking at it.
Yes, sir.
Yeah, they've already changed it over to organized retail theft. It's the last one in blue.
Okay.
But it's not actually been.
Yeah, I looked yesterday. I didn't see any filings, but.
Can I?
Are you, sir? Not this one.
All right, I'm looking at a probable cause affidavit prepared by, I guess it was, it's a
It's also filed with BPD, Judge.
Beaumont PD.
Yes, sir.
Okay. And this alleges that on June 27th, which is about 3 to 4 weeks ago, at 6:37 in the evening, officers were dispatched to Walmart on Dallin Road here in Beaumont, Texas, in response to a theft, and 3 females were walking in the wooded area. They made contact with the females who dropped several black bags and one blue bag. They were detained, including this defendant who's in front of us today in this case, and Walmart loss prevention claim. They had observed all three females conceal stolen property inside various bags before leaving the store, and the estimated loss was about $300, and they wished to file charges. Again, this was on June 27th, 2026. And these two cause numbers pending before the court, 26C0747 and 748. This defendant, Ms. Boudreaux here, is charged with credit or debit card abuse, state jail felonies, and it is alleged in these indictments that she committed these crimes on or about December 10th of 2025 and on or about January 24th of 2026. The defendant posted a bond. By the way, these indictments were both, these earlier indictments were filed April 29th of 2026.
Okay, good.
About a month later, in May 28th of 2026, the defendant is posting a bond of $4,000 in each, two bonds of $4,000 each in each of these two indictments that had been filed. And then again, she posted a bond on May 28th of 2026. And then she is arrested a month later after posting bonds on these two cases with a third crime of the theft at Walmart. So there is a motion to increase the bail. And I have in 747, but she's also charged in 748. I don't have a motion.
Judge,
I filed it in both, Judge.
I can print the one for.
What's the state asking for here?
Judge, we just have an increased concern about the safety of our community because of a continued violation. We feel that the bond, obviously, it's set, it's not got our attention. We need to have some increase in some.
What are you asking? What do you think is fair?
What was the bond amount on these, Judge?
4,000 each.
I would suggest 15,000 on each, Judge. Minimum.
Go ahead.
Judge, my understanding from what's coming around, I know that the two existing cases, I have those, but this new one is, I haven't gotten much other than the PC on it. It's essentially a shoplifting allegation. Would you mind if I have copies? I ain't going to show. So
Of this?
I don't have a copy of the
Is that what you want?
no, I don't have a copy of the motion.
Oh, okay. Do you want one for each case or
Just wanted to do the same thing.
Yeah.
But my understanding, none of these crimes are violent, this isn't a to be because I don't know that Mrs. Boudreaux can afford $15,000 per case, which,
There's a way to avoid this.
well, but it becomes this shouldn't be an instrument of oppression or a penalty. It's a bond. So
Well,
and none of these are
what's,
violent cases.
what does it say when someone is arrested, indicted on 2 felonies, and then within a month is committing a similar type of felony offense, or this is a theft. I don't know how it's going to be filed, but it's another crime of moral turpitude.
And then also to know that she starts a job today.
Yeah, maybe, but there's a way to avoid all of this, is to be honest.
Well, Judge, I think as the facts may bear out with this new case, having talked to my client, I think it might show that she was with a group that doesn't necessarily can make it better. But I think that the group that she was with may have been the perpetrators more so than she. Again, that's going to hopefully bear out in the case, but as it stands here today, I think she was just with the wrong people. I told her earlier that these are not her friends. These are people that are getting her in trouble. So friends don't get you in trouble.
No, but your choices that you make is what makes you responsible. And somebody who had just been through the system, arrested, had to post bonds, I would think they would be on high attention about dealing with others. And let's see, there's a
I think it's important to note on that PC, which is a conclusory statement by the police, that Ms. Boudreaux was with the group. The other 2 girls that she was with were the ones that were actually had stuff on their person as well.
I'm sorry, the loss prevention claimed they observed all 3 females conceal stolen property inside various
Which
bags.
is a conclusive statement, but if you reads further, they'll note that the police officer making the arrest found stolen items on the other 2 and not Ms. Boudreaux.
Anything else?
No, Judge.
Your bonds are revoked. Warrants are issued for your arrest, and you must post $15,000 bond in each of these cases. Plus, you will be on home confinement because we don't trust you going out and continuing to apparently commit the same kinds of crimes of theft. It costs everybody else who's honest for the loss. You must be on home confinement. You have to have a GPS device. You can only leave home to and from work in the most direct route possible, to and from court, to and from your attorney, and to and from to get food. And otherwise, if you fail on that, your bonds will be revoked, and there probably won't be a bond next time, because these are you're required to follow the conditions of bond. And the last condition of bond that you were given before you were here for this new case was don't commit another offense. So
To be clear,
honesty is always a good thing.
To be clear, it's 15 on the 2 credit card uses.
In each of those. Yeah, that's $30,000.
Thank you, Judge.
Anything else? What's next? Next event? Set it for trial, or this?
They've got to file the new case so that maybe we can work something out on all of them.
Give us another announcement date, and I'll make an
All right, announcement in
4 weeks, Judge.
Is that
just
good?
to be
4?
safe.
All right.
You can post it. You just have to do.
And those are both cases, 747 and 748, the orders. Okay, I have Steve Savoy. Steve Savoy. I've got Darren Patterson on Tom Burbank, but I hadn't even seen Tom. Is there any Darren Patterson? Have you seen your attorney? This was a drug patch issue. Let me look at what this issue is. Darren Patterson. You know, I've got a Jordan Edmondson.
Yes, so that was an add-on.
No,
He's set for trial on Monday, and I think this was kind of the last minute.
Yes, he'd been waffling on the offer, Judge, so we just wanted to make an official acceptance or withdrawal. And I want to withdraw the offer.
Huh?
I want, if he doesn't accept the offer today, I just want to withdraw
What
it
you gonna
and
do?
then we're,
Okay, well then, we're set for trial, no deal. Okay, just tell him. I don't think he needs to come out here.
Okay.
So that's, so when is it set for trial?
Monday.
All right, be ready, because we want to pick a jury maybe, probably. That's, and then.
That's what you know what you're doing. Yes, I was gonna say that.
Well, I see on this Patterson matter, we've been having, I'm surprised, Tom isn't here. Where's Tom Burbank? He's normally here. Well, I got a warrant for his arrest. His bond is with her. His bond is gonna, he's always busy. Okay, so,
Maybe stuck in another court. I'm not sure, Judge.
so on Patterson, who failed to appear, I made my findings.
No, Mr. Patterson is here.
Where's Darren? Right there. Okay.
William.
Well, yeah, it was.
Yeah.
Judge Burbanks in the drug court.
Okay. It says drug patch issue. What's this about? Who's Miss Moore? Miss Moore, on yours, on this, Darren Patterson, it says drug patch issues. What can you tell it? That's all it says, huh? I'm not sure what this is. Probation?
the note about. So the defendant last tested February of 2025 and April of 2025, and he was positive for cocaine those 2 days. He did not he never came back in until July 2nd of 2026. And when he came in July 2nd of 2026, he did not have a new patch. He did not have a patch on, so they put
about a year and a half.
yes, from April of 2025 to July 2026. When he came in July, he did not have a patch on, so they put a new one on. He was supposed to come back every 2 weeks, so they haven't seen him since July 2nd of 2026. So he didn't even go back in the 2 weeks to get the July 2nd.
Do you have a patch on that? I have a court order on you, sir. Failure is not an option. You're supposed to have a drug patch unless I say otherwise. How long has he been without a drug patch?
He got one July. He went.
But it's best, don't say anything because I want your lawyer here with you, because this is serious. Because what can happen is I'm going to revoke your bond. You're going to sit it out in jail until we try this case, which could take years.
They put one on him July 2nd of this year. He was supposed to go back in
this month?
Yes, sir. He was supposed to go back in 2 weeks to have it tested. So it was put on July 2nd. I don't know how long it's been off. Today's the 22nd. He didn't report back in the 2 weeks to report it that it fell off or to get it tested.
And where's Mr. Burbank? I mean, he needs to be here for a hearing on this. We have to have a hearing. I'm not letting you go you're not leaving the building until we have a hearing on this today. And I've got a trial I've got to get into. Well, that's our marching orders but you just stay close by. No, I got to go to trial. I got to get into this trial. But we're in test. Thank you. Here's this. Thank you. Come on up, Tom.
No, and I thought because of the communications and drug court, I was over there.
That's okay.
I'm sorry.
He's tested positive again
Oh,
for benzodiazepines that he had tested positive with back in the last time.
Judge, it looks like you originally ordered that drug patch November the 19th of 2024.
That was
the
when he
original.
first tested positive for
Correct.
drugs that first time.
Raised his bond, looks like we raised his bond. To $100,000 in each case, May 8th of 2026.
And drug patch.
Drug patch GPS device.
You have a GPS device, but you don't have a drug patch.
It'd be falling off every time I get it 3 days.
Notwithstanding that, you tested positive for drugs today. Your bonds are doubled once again. You're at $200,000 on each case. And if you can post that, you got to have a drug patch at all times. That's the orders of the court. You're taken into custody.
Do you want to continue to have the GPS below?
Yeah, he has, it's the same,
Okay.
he's under the same orders as before.
Yes, sir.
Just not following the orders, but they're the same orders.
you placing him in custody?
Yes, he's in custody and his bonds are doubled. We'll keep doubling. Until all the money runs out on the universe.
All the money runs out in the universe? Oh, we'll keep doubling it until all the money runs out in the universe. Oh my God. Yeah. So we began with a guy telling the judge that the FBI was going to be all over this stuff because this jail is just so horrible. And he knows how to win his case and he doesn't need a lawyer and all that type of good stuff. And we end with the judge telling a guy, we'll just keep doubling it until it's all the money in the universe. I get the feeling he's not going anywhere for quite a long time. $400,000 bond. Oh my God. I'm sure it'll be back up for reconsideration at some point. He might get out for a while until he goes to trial. Maybe we'll get to see that trial. Maybe we won't. I don't know. There have been some interesting trials going on this week, all week, and I've been watching them with a close eagle eye. I'm kind of worried about the one in Judge West this afternoon. I didn't see them come back, and they just kind of poofed out. Kind of like not an ending or anything. It was just the jury was out, and then they were out for the longest period of time, and then just went poof. Oh my God, ladies and gentlemen, I've got to say a big old thank you to Vega Starlight. Oh my gosh, so thank you. Thank you for your contribution to the channel. She wanted to point out quite accurately that there's probably not any such thing as a sober golfer. And yeah, I'm not gonna say she's wrong. Not with a super chat like that. Ooh, sir. If it's not true, then it's true right now, today, for me. Whatever. Starting the credits now. And this is what they look like. You're gonna see Starlight Vega's name at the very top right there. No, Vega Starlight. I got it wrong. I'm a goober. Thank you so much, Northwest, Rhonda, Lisa Cat Mom, and Mama. And Mama. Thank you, X25, Unbiased Jurist, Charlene Tutt, Straw Carpenter, Vermiticus, Alley Song, Mr. Beats, Patrick, Hopris, Carl's Last Order of the Squirrels, Squirrel, Mark Baggett. I know that name. It's a pretty cool dude. I know I saw an old squishy gardener out there somewhere too. That's kind of a cool cat. Mortimer Duke is here. That's another cool cat. I don't know. Mortimer Duke's kind of questionable. I don't know about that guy. Ladies and gentlemen, thank you so much for being with me tonight. I do the same thing every single night of the week. Same wolf time, same wolf channel. Around 8 p.m. Central Time. Come on by. See what I got going on. We'll have more tomorrow. Until then, I am out. Go. And remember, only you can take a bite out of crime. Bye. Darth Steven Objectioner, why are you still here? We've got nothing else. I'm not doing these Ferris Bueller things every single night.